Welcome back to Digit Debate. So it's lovely to have such a great audience here today. And my name's Jackie O'Reilly. I'm the co-director of the centre. Sorry for our little pause in proceedings, which is due to setting up our next 5 years of funding, which we're very grateful for to the ESRC. And we're very pleased today to have Simon Deakin and his colleagues from Cambridge, Camilla and Christine, who have also been working on this project. Simon's project was initially funded through the first phase and subsequently now into the second phase to look at the Cambridge Business Research Labour Regulation Index. And today's talk will be about looking particularly at platform workers and the changing relationship of employment statuses there. And we're also very lucky to have today with us as discussants Tim Sharp from the TUC, who is former editor of the Scottish Herald newspaper, but for his sins now, he is the senior employment rights officer at the TUC, working on employment rights and legislation, amongst many other good things he does. And also Aída Ponce de Castillo from the European Trade Union Institute. Aída has a very wide body of research around issues around surveillance and regulatory issues of human genetics and bioethics, nanotechnologies and emerging technologies. So we're really grateful to have both of you here today to comment on the work that's been done at Cambridge as part of the Digit Centre. So with no further ado, I'll hand over to Simon. Oh, sorry, I didn't introduce Simon. Simon is our eminent professor from the University of Cambridge, who's just a wonderful colleague we've worked with for a number of years. He leads the Cambridge Business Research Centre and has a very long reputation on working on labour regulation and business organisation. He has conducted research in Japan, China, Russia, India, and South Africa. And he always has lots of interesting things to say. So thank you very much, Simon, for telling us about the new work you've been doing.
Thanks so much, Jackie. Sorry, I just realized I was on mute. Let me try sharing again. Here we go. Thank you very much, Jackie, and thank you everybody for attending this afternoon. I hope you can see my slides and hear me okay. Okay, great. So in this presentation, what I'm going to be doing is, first of all, introducing the index that we have been working on here in Cambridge. This is work I've done jointly with Louise Bishop, who's also here, Christine Carter and Camilla Porcamani. I'll contextualize the legal debate over employment status and then talk about the methodology that we have been using to create the index. Then I'll present the results of the index and give an assessment. So first of all, the index itself. This is an index which codes for legal developments concerning a specific issue relating to platform work, which is the employment status of platform workers. And it's an index which covers 95 countries for the period 2016 to 2025, effectively the last decade or so. So the index has already been published. It's available on Cambridge University's open access repository, Apollo, and it can be consulted now and also can be downloaded and used for research purposes. It's published with a CC BY license. There's also a Digital Research Centre data commentary, which explains a bit more about the index. Employment status, what's the issue here? Labour laws and social security laws have existed in something like their current form for around a century, and they came into being to protect workers, broadly speaking, from physical, economic, social and psychosocial harms arising in the course of employment. So this type of regulation is well established, but may not apply to workers in a platform economy if those workers do not have so-called employment status. So legally, in virtually every labour law system, the status of employee or worker or an equivalent term might be used to describe the status, but it's pretty much the same everywhere. You need to be an employee or worker to be protected by labour law, health and safety rights, wage protection rights, limits to the working week, but also to participate in social insurance schemes. Normally, employee status is needed, and that's a gateway to unemployment compensation and retirement benefits. Also, there are tax law implications because income from employment is taxed differently from income from self-employment. Now, the distinction between employment and self-employment doesn't exist in nature, has no natural existence. It's a legal creation, and it was created for a purpose. It was created in the early 20th century in different ways and different systems to express a different set of governance mechanisms for risks arising in the labour market. So classically, the self-employed, or people who were described sometimes as independent contractors, were not completely excluded, for example, from social insurance law. They often do pay social insurance contributions, but get different benefits because they may be paying at a different rate. And those who receive their services are not always employers, and so would not be liable to pay secondary national insurance contributions, or class 2 national insurance contributions in this country, and employers' contributions elsewhere. It's not the case that the self-employed are completely excluded from social security law, and nor historically were they entirely excluded from labour law, because many independent contractors in history have had the right to organise in trade unions and to take part in collective bargaining. But increasingly in recent years, there's been a certain rigidification of the binary divide between employees and self-employed, with self-employed workers falling outside the scope of labour law, in particular in the gig or platform economy. So for present purposes, I'm going to define platform work as work which is provided for or through a digital platform. And a digital platform is, in essence, an intermediary which uses digital technology, apps and algorithms, to put clients in touch with service providers and vice versa. So those service providers may or may not be workers or employees in law. They may not have a contract of work or employment with the platform. They may contract directly with the client to whom the service is provided. Fine. In platform companies, especially in the ride-hailing sector and also in food delivery and increasingly in areas of healthcare and social care, the platforms tend to take the view that they don't employ anybody. They are pure intermediaries. They put workers in touch with clients or service providers in touch with clients. If a platform can be classed as an employer, then they may have labour law obligations, and a platform worker, if they're an employee or worker, will have rights against the platform, not against the ultimate client. Now, the default position is that platform workers are self-employed, independent contractors. That's the view of many platforms, and has also been the view of many policymakers, and to some degree a view also in the academic community. Social scientists researching this question would discuss the fissuring of the employment relationship, intermediation, fragmenting of the traditional employment form. But the law on this issue has not stood still. And as I'll explain in a moment, in the course of the last decade, there have been a number of developments which have tried to clarify the employment status of platform workers. And one in particular, which is internationally relevant, but especially for mainland European countries, is the EU's Platform Work Directive, which does a number of interesting things. First of all, the Platform Directive attempts to clarify the employment status of those providing work through or for a platform by introducing a presumption of employment status where there is an element of control by the platform over the way the work is done, essentially. The Platform Work Directive doesn't itself create new rights as such, but it requires member states of the European Union to amend their laws to introduce an employment status presumption in those general terms. Also, the Platform Work Directive provides rights to people who work through or for a platform, persons performing platform work in the terminology of the directive, even if they are not employees or workers, according to employment status tests. So somebody who is not an employee or a worker is nonetheless protected with respect to certain digital rights, such as the right to receive information about automated decision-making systems, automated monitoring systems, the right to a human review of certain decisions, and equally, platforms, whether or not they're employers, have digital law obligations which correspond to these new rights. So the Platform Work Directive is an extremely important measure, essentially for what it does. It's creating a floor of rights for all people who work in or through a platform, whether or not they're employees. And those are the digital rights which digital law supplies. Above that basic platform, labour law will apply, rights to collective bargaining, rights to union organisation, rights to the minimum wage, etc. If a worker who's providing platform work counts as an employee, broadly speaking, or a worker for labour law purposes. Now, to try to capture this information, this very detailed and complex legal information, in a form which can be used in statistical analysis and would be of interest to social scientists who may not have a detailed legal training, what we've attempted to do is to build an index which summarizes the information contained in laws around the world and attempts to rank countries according to the approach they've taken so far to the employment status question. So what we're attempting to do here is create a so-called composite index. There's a well-known methodology for doing this. We're not the first people to do it, of course. The OECD, the Organization for Economic Cooperation and Development, an international think tank or agency, has published most recently in 2008 guidelines for constructing composite indices. And they define a composite index as a quantitative or qualitative measure derived from a series of indicators that can reveal relative positions of countries with respect to regulation and can also benchmark change over time. So an index is useful for inter-country comparisons and intertemporal comparisons. Indices, it has been said, are like a kind of mathematical or computational model, but maybe there's an art involved in creating one. The OECD talks about the craftsmanship of the modeler. And there are, of course, many ways to create an index, not just one way. But there are methodological protocols around the concept of construct validity, which we've sought to follow in creating this index, and also the wider index, which in a way is the parent index for the Platform Work Index. That's the so-called Labour Regulation Index, which, as Jackie was explaining, Digit One funded, or they funded an extension of that index that covers labour laws as a whole for over 100 countries for the period 1970 to the present day. To create an index, we need a coding template. And the reason we have a template, which is a kind of verbal algorithm, is to ensure consistency in the coding. So the way we do this work is 3 or 4 of us read legal texts for the countries concerned, and we apply the coding template that we ourselves have developed to rank countries according to the type of laws they have. So we have to identify the different types of laws that exist in an area. Then we rank the laws with a higher score indicating more protection for workers, which in this case means it's more easy to establish that you are an employee or a worker while working through or for a platform. So 0, the lowest score here, is where in a given country, in a given year, there's really no case law or no legislation challenging the default of independent contractor status. So 0 is the view of the platforms that they don't employ anybody more or less prevails in national law because there haven't been court rulings or statutes questioning that presumption. Next up, the next level, we code 0.25 out of a 0 to 1 scale, where social security law counts platform workers as contributors to social insurance for certain purposes. And so they will get some rights, maybe a retirement pension, if not necessarily an employment compensation. Point 5, halfway through the scale, is for countries where platform workers have certain rights, even if they're not employees or workers. And those can include the right to collective bargaining and the right to minimum wage protection. For example, in the UK, if you're not an employee, you might still be self-employed, but you might be a so-called LIMBY worker. So the LIMBY worker is somebody who, in most respects, is self-employed, but has certain labour law protections because there's an element of economic dependence on the platform, which is thought to be appropriate for certain legal purposes. So in the UK, a so-called LIMB worker or a dependent contractor in Canada would have health and safety protection, working time protection, minimum wage protection, and conceivably the right to collective bargaining protection. Without being an employee necessarily. So these are so-called third category countries where there's a category in between employee and independent contractor status, which grants certain rights. 0.75, a higher score, is where a court, an apex court like the leading labour court or the Supreme Court in a country, has said platform workers can be classed as employees if there is control. Often there is control in the way platforms work. They may surveil the platform workers, they may rank them, they may exclude them from the app if they don't do a good job. These elements of control may be sufficient to find employee status. And finally, we code 1 if the law in the country concerned contains a presumption of employment status. The first of these, in a sense, the model for all the others, was the Spanish Riders Law from 2021. A similar law shortly after was enacted in Portugal, and it's in a way kick-started the process which led to the Platform Work Directive. Now, the score of 1 here doesn't mean perfect protection. It just means the highest protection we observe internationally so far. And these are relative scorings. Also, these scorings are not an attempt to code for the way platform workers are treated in practice. We don't have data on that. It's possible to obtain data on the lived experience of platform workers through case studies and through surveys, and other organisations and other research units have done that. All we're coding at the moment is the content of the law using the text of those laws, so-called jural or textual coding. It's a text-based exercise, not necessarily, of course, then the way workers are treated in practice. And indeed, there may be a big gap between law and practice. So let me now discuss our results. What we've done here is we've put into 2 charts the codings, the scores, for the period of the index, which is 10 years up to the present day. A higher score on the vertical index indicates more protection for workers because employment status is easier to establish. And we've averaged here the scores for all the countries in the index, all 95 of them, and for OECD countries, those with a longer history of industrialization and economic development. So as you can see from the left-hand side chart, the score has been going up steadily over time. Very few countries had laws in place already in 2016, but by 2021 there's a rising trend, and that trend has continued to go up, including most recently into 2025. OECD countries, developed countries, you might say, have more protective labour laws in this respect than the all-country average, right? So we especially see developments, but not only in Western Europe and in North America and in East Asia, we see developments, but we do see developments in some other countries too, which I'll come on to. The right-hand side chart takes the average of the LRI index, which is all types of labour law, essentially, not just those relating to platform work. So you can see from the right-hand side chart that over the last 10 years, the degree of protection in respect of labour law as a whole for OECD countries and all countries is static. It hasn't gone up or down significantly. So platform work, it's gone up. So I think we can say that with respect to platform work and employment status, we're seeing a lot of activity in labour regulation over the last 10 years. more so than in labour regulation as a whole, which is not changing all that much up or down. In more detail, country-specific development. So getting below the level of the index to a more fine-grained, more qualitative analysis of what is happening. In over half the countries, there's no change at all. So over 50 of the 95 countries, we don't see a change. By the way, we only code 95 because those are the countries we can find information on. For some countries, we either can't find a law or we can't find a debate about why there isn't a law. Okay, so that's why there are 95. We can add more countries later if we get more information. And please do get in touch with me if you know of information we haven't included in the index. We'll include it in a further version. But we do see some very interesting variations. So, for example, in Brazil, which is a country where platform work has been growing quite quickly in the ride-hailing sector, food delivery, and so forth. On average, across all countries, those sectors don't account for more than 3 or 4% of employment. So we're not talking about huge numbers, but in Brazil, it's larger. So in Brazil, the Supreme Court has asserted recently its view that platform workers have independent contractor status. And the Supreme Court has tried to say that this should be a strong default, that there needs to be very clear evidence against independent contractor status to establish employee status, and the Supreme Court has been pushing back against the Labour Court, which has taken a somewhat different view. So there's a bit of a constitutional tussle going on between the Labour Court system and the overall Supreme Court in the Brazilian case, which is very important and interesting. So Brazil's a case where basically nothing has moved on, thanks to a judicial intervention against employee status, I would say. But that debate is still going on and has yet to reach a definitive conclusion. Then there are countries where courts at national labour court level or Supreme Court level have been moving towards findings of employee status. So around the world, essentially it's the courts which have been doing most to establish employee status, not legislatures. Courts in civil law jurisdictions tend to see employment status questions as issues of public policy, not issues of pure contract law. So applying the purposive or policy-based interpretation of employment status, courts in France, Germany, the Netherlands, but outside the OECD, in the Philippines and in 1 or 2 other Asian countries, have been finding employee status through judicial action. Now, even 1 or 2 apex court judgments won't completely settle the issue. France is a good example of the courts doing one thing while the legislature is doing something else. So French legislature has passed laws specifically for platform work as a third category. So reduced protections, but some protections. And it's also possible in France to use laws on setting up micro level companies. Micro entrepreneurship for platform work has been very much pushed by the Macron government. So France is not a completely clear picture, but the courts are doing one thing, protecting workers on the whole. The legislature more inclined to a so-called flexible approach, I guess. The USA is also a very interesting case because although American labor law as a whole globally is weak and has recently been becoming weaker under the new Trump administration. However, in respect to platform work over the past decade, US courts have been as dynamic as courts anywhere in developing employee status tests, which take into account essentially what might be called the reality of the relationship of dependence and control, rather than focusing on form or contract. The so-called ABC test essentially asks whether the platform is running a business which requires labour inputs, and conversely, whether the worker or service provider has an independent business with independent capital and assets of their own. So it's really a business focused test. Who's running the business here, the platform or the individual? And the ABC presumption is strong in many states, such as Massachusetts and California. However, we also see in the United States strong pushback from legislatures and in some cases from statewide ballots, which take place in states like California and also in Massachusetts. In response to the court rulings in California and to a Californian statute with a presumption of employee status for gig workers, Platform companies like Uber and Lyft invested spent tens of millions of dollars campaigning for a ballot proposition, Proposition 22, for independent contractor status for platform workers in ride hailing and food delivery. Although even under Proposition 22, there are still some very basic minimum wage protections. So if anything, in the United States, the initial surge in favor of protection has been pushed back a little bit by platform company interventions, but it's a very fluid debate, a lot of diversity. We've coded the US 0.5, but it's very hard to code a federal system, of course, and we may need to do a country-specific coding state by state later. In Massachusetts, a very interesting recent development from last autumn is a legal model under which gig workers and platform workers in ride hailing and food delivery would have the right to organize in trade unions or would have the right to collective bargaining, even if they were independent contractors. And the Massachusetts law takes advantage of a very odd feature of American labor law, which is that state level laws on the right to collective bargaining and the right to industrial action may not preempt, or rather are preempted by, may not occupy the field of federal labor law, the National Labor Relations Act. The National Labor Relations Act is very clear that only employees have collective bargaining rights, and also that on the whole, platform workers are not employees in federal law. But the fact that platform workers are not employees opens up the space for Massachusetts to say, we'll have a law for platform workers who are independent contractors. They can regulate in this space without being preempted. So there's a new law which grants independent contractor platform workers collective bargaining rights, which is extremely interesting. So if anything, there may be a trend towards providing platform workers with labour law protections regardless of their employment status, which I think is another very interesting route that a number of countries are taking. In the UK, the law is, I would say, labour lawyers, of course, might take different views on this question. I think the law is a little bit in limbo following the Uber ruling in favour of worker status for gig workers and the Deliveroo ruling, which is somewhat more formalistic and to some degree has allowed substitution clauses to be used to deflect worker status. But it's a complicated legal debate. We've coded the UK at 0.5 to reflect the lack of a clear, completely clear position from the apex court and lack of a statutory presumption. The current government is consulting on introducing a reform to employment status, but has not yet produced a draft bill on that issue. So our assessment then overall would be that even as platform work has been increasing, it has been increasing, although ride hailing and food delivery in most countries would represent less than 5% of the entire workforce, but maybe app-based or algorithmic work is spreading to social care, healthcare, maybe even to education. There are more platform workers, more workers working through platforms, but also over time, more are qualifying for employee or worker status because of judicial and statutory development. So through legal evolution, the law has been catching up and catching up quite fast. This has all happened in the last 5 to 10 years. The principal obstacle to including platform workers within the scope of labour laws is no longer, if it ever was, legal uncertainty or complexity, but quite simply the lobbying power of platform companies and the influence they have over legislatures in particular. Limitations of our study, I've mentioned one, it doesn't refer to the actual working or lived experience of platform workers. One would look elsewhere for that. There's plenty of evidence from the Fair Work Project and other academic initiatives, a large volume of material relating to the actual experience of platform work. All we can do here is talk about the law, but at some point we'd want to link up to that wider literature and see whether the law is making any difference in the countries where the law has been strengthened recently. Also, outside the scope of our study is algorithmic management more generally. We're not looking here at the regulation of platforms inside organizations or inside companies. A large platform company like Amazon operates both as a platform, sure, but also as an employer with respect to its warehouses, for example. And digital management goes on inside inside the workplace. That's not covered by our index. We're not coding here for general labour law as it applies to the use of digital technologies, where there's admittedly an employer-employee relationship. We can consider that in future, but the main index does code for many of these laws. We are not coding yet for specific digital rights, such as the right to be informed, the right to human review, the right to information about automated decision-making and automated monitoring. Those rights contained in the Platform Work Directive and to some degree in the AI Act are gradually coming in at member state level inside the EU and elsewhere, but it's a bit premature to try to code for those at country level, but we would expect to code for those in a future iteration of the index. Well, thank you very much for listening to my presentation, and I'm now going to hand back to Jackie.
Well, thank you very much, Simon, for a very thorough and yet concise summary of the work you've been doing. Tim, would I like to hand over to you to get the UK perspective on how you see these developments in the platform sector and its implications for labour regulation. Thank you very much, Tim.
Absolutely lovely. And contrary to the kind introduction I had earlier, I don't think I ever made it to as high as the editor's seat on the Herald newspaper, but I was the Herald's journalist in the City of London, watching Capital at work for a decade, and now I work for Labour at the Trades Union Congress, which brings together 48 trade unions with 5.5 million members between them, and I lead the TUC's work on employment rights policy. I'd start off by saying that we regard this as a really valuable piece of work, particularly helpful in getting us out of a sort of very narrow UK focus. From a TUC perspective, it gives a really useful framework to assess where does the UK stand in comparison to other countries, and gives that sense of a change over time. I was hoping just to make a few opening points for context, and then discuss three broad areas where the TUC believes we need reform in order to sort of better protect the interests of platform workers. I think the first is to note the likely scale of the platform economy. It's quite hard to pin down numbers, and it's easy just to look at those who are sort of visible on the streets, delivery riders with branded kit, for example. But we know that the platform economy accounts for a very diverse group of workers doing many roles, from doing sort of micro tasks on their computer to translation work to, as Simon touched on, elements of care work increasingly as well. We published some polling data that showed that back in 2021, we estimated as many as 14.7% of working people in England and Wales were undertaking platform work at least once a week. So that would be about 4.4 million people, and that was over double what it had been in 2016. And polling found that a quarter of workers had done platform work at some point. So that gives a sense that it does imply a very wide reach for the sort of platform economy. But I also think we need to be quite careful, particularly when it comes to considering policy solutions to issues raised by the growth of platform economy, about the extent to which we separate the concerns of platform workers from, I guess, wider workers, or a wider category of vulnerable workers. We've long had people in the workforce, domestic and office cleaners, for example, who have struggled to enforce their rights, whose employment status perhaps has been questioned. So let's just be careful at the extent to which we think platform workers, because they're hired via an online app, are unique and therefore require unique policy solutions. And I think linked to this is, I think what can be one of the sort of great deceptions, I guess, of the platform economy era is the claim or the perception that the rise of the platform economy is solely down to sort of clever tech bros and their whizzy algorithms. There's a strong argument to make that where the innovation has lain in many cases has been a willingness by platform operators to exploit loopholes, vulnerabilities of employment laws, and shortcomings of sort of legal and enforcement regimes. It's only possible to have a business model based on having lots of delivery riders waiting around to be deployed at any second if you aren't having to pay them for waiting around. And this is another reason why we really appreciate this work like this that's been produced for Digit. So analysing the protection given to platform workers is so really useful in this context. And just a final sort of introductory point I was going to make is, I think we should also have reasons for optimism. Simon touched on some of the sort of legal progress that platform workers have been making. I think I would also note the willingness of platform workers to challenge the status quo. We've seen that in the courts, and we've seen that in organising in workplaces, and we've seen that in the way that in some contexts workers have been brought together to analyse how the algorithms behind platform work are working and scrutinise that. And another reason for optimism is the current government has made commitments to help gig workers. They made particular commitments around trade union rights, ensuring that the rules are fit for a growing platform economy. And they've also pledged to move towards a single employment status for workers. And the TUC and our unions will be working with the government and holding it to account to trying to ensure that it does that. So there are reforms in three key areas, not all directly related to law, where we think change is needed. One is explored in depth in the sort of paper in front of us, and that's the issue around employment status. TUC has long argued for a single worker status. We see no reason for having two classes of worker, one of whom has full rights, and then including, crucially, unfair dismissal protection and parental rights, and then another group of workers who get an inferior set of rights, which is limited to things like the minimum wage and paid holiday. Many in the platform economy will fall into that latter camp, though even then it's often taken lengthy legal battles to establish that. But we're also aware that merging the two will be complicated and lengthy, and it's important that there are not consequences that might leave workers worse off. We think there's perhaps a more pressing and urgent issue around the boundary of workers and the self-employed. I think it's crucial that more vulnerable workers are brought within the worker boundary to gain the protections the law is meant to afford them, and ensure that that's enforced. As it stands, too often an engager and employer can seemingly just decide that someone is self-employed. So on practical grounds, we think you should tighten the test for worker status, noticeably on substitution clauses. At the moment, when the test for workers status is, can someone else do your work effectively? We believe that the requirement to undertake any work personally should be sufficient to meet that test. Just because your contract says you can, and maybe now and again you do have someone else do, for instance, your deliveries, shouldn't exclude you from the protections that the law is meant, that Parliament has meant to afford people in your circumstances. And a second key element would be a presumption of worker status. I mean, something that is addressed in the EU directive on platform work. We think perhaps the most appropriate formulation in a UK context is that there should be an assumption that when a case is taken to tribunal, that someone is a worker with all the rights that entails. Then the onus will be on the employer to show that that person is not a worker, if that's what they're claiming. So first area, we think reform employment status. Secondly, and it's obviously related, but we think you need to consider trade union rights. Union recognition and a strong union presence in the workplace is the most effective way of workers pursuing their interests. There's strong evidence about the impact on wages, inequality, productivity, and the effective response to industrial change, where you have collective bargaining going on. And these arrangements allow workers and employers to negotiate arrangements around pay and conditions, for example, can provide a more informal route outside the legal system for disputes to be resolved. Now, trade unions are making some progress. There are some collective agreements in place with key operators, including Uber and Deliveroo, notably facilitated by a Supreme Court judgment regarding the worker status of a group of Uber drivers. But it does remain very hard for unions to organise workers where there isn't already an established union presence, and particularly workers like many platform workers, virtually all platform workers, who are not in a central workplace. The Employment Rights Bill currently going through Parliament does take some important steps to improve that. It will bring in a union, if it's passed, it will bring in a union right of access, including a digital right of access, which implemented, and if it's implemented and enforced well, should give unions an in sort of new parts of the economy, including the platform economy. The legislation also should reduce some of the barriers to unions gaining formal recognition rights and make it harder for employers to use unfair practices to block them. And we know that many platform operators are keen to resist a union presence in the workplace or among their workers. We are urging the government to implement these, once they've got roll assent, to implement these measures as quickly as possible. The bill also brings in the first sector-wide fair pay agreement, in this case in social care, to allow bargaining between workers and employers across this whole sector. Social care has been picked on first because of the issues of insecurity and low pay. I mean, this is what Simon touched on, one of the areas, sectors where there is a sort of growing platform presence, but you can see a similar case could be made about other parts of the labour market where there are similar issues of insecurity and poverty, where it would make sense to have sector-wide agreements. And we know there are employers such as Royal Mail, for example, who are keen to see sectoral bargaining in their sectors to avoid undercutting by platform operators. And again, I think we've sort of been touched on in Simon's presentation. The final point on trade unions would be we need to consider whether it is appropriate for employment status to be a gateway to trade union rights. We know it can be a barrier to recognition. It potentially weakens the hands of unions who do have self-employed members where there are voluntary agreements, but they're in a weaker position if they know these could be swept away at any moment. And then just the third area I would like to quickly touch on, and Simon mentioned it towards the end of his remarks, is that around surveillance and technology. Again, this is not an issue that's unique to the platform economy, but platform workers are at the forefront. Issues around algorithms effectively being used to decide who's hired, who to deactivate workers, to allocate work, and to determine payment for work. The algorithms are often opaque, and the technology in its broadest sense can go wrong. Notoriously, there was a discriminatory effect. I think it was at Uber, where a driver was deactivated after the app struggled to recognize a brown face. So it's vital that we ensure in those cases that individuals have access to data and the ability to challenge unfairness. But I think we also need to be more ambitious on collective rights. Around data. The data use and access bill is going through Parliament at the moment. Feels like a bit of a missed opportunity in relation to new digital rights. It could have included provisions facilitating trade unions to have enhanced collective data rights and to collectivize worker data. Such rights would allow unions to aggregate and analyze workers' data, identify where workers are being treated unfairly, and potentially provide a basis for bargaining for a better deal. So, and just to conclude, I mean, we think this work published by Digit today is really important in this emerging area. And as a final point, those in more conventional jobs shouldn't be complacent. We think that many of the issues we're seeing in the platform economy are spreading to the rest of the labour markets. Just look at the attempted use of freelance retail workers over Christmas recently, or increased management by algorithms. So we think that, the struggle of platform workers for a better deal and for fairer treatment is something that should concern all working people. Thanks, Jackie.
Thanks, Tim. That was fantastic. That was great. Now I'm going to hand over straight away to Aída from the European Trade Union Institute, who's going to give comments from the perspective of Brussels and elsewhere.
Thank you very much, Jackie, and hello, everybody. I will first congratulate Simon and the team involved for having produced such a useful piece of evidence. And I would like to organize my comments in 4 parts, if I may. The first one will be a set of comments related to the usefulness of this tool, if I may. The index is really a practical, quantitative method to measure and compare how much legal protection platform workers have in different countries in the world from a decade. So it gives us a really clear and very broad picture. Secondly, it allows also to compare countries with very different legal traditions and different levels of economic development, and that also gives us a very broad view of their differences and the inequalities. And of course, and the index also contributes with more evidence on the necessity to govern or continue governing the work on platform and how they are evolving in a way. It complements the work that has been done already, as Simon has mentioned, by Fair Work, but also by my colleagues at ETUI and by Antonio Castillo in France. My second strand of comments is the good news and the less good news that I have learned by reading the findings. The index shows that the legal protections have an average increased over the past decade, with average protections across the OECD countries that we know the most. But also it makes evident, which is much more striking, that half of the 95 countries have made very little improvement and between these 10 years. And from these half countries, the score that the team attributed is score very, very low, which is very striking, even in big countries such as Brazil or South Africa. But also, I think that this opens many questions to reflect upon for future research. And one of these questions is, for example, how do these formal legal protections, especially in Europe, perhaps because we have the Platform Work Directive, translate into enforcement? How can the judiciary and the authorities involved can really enforce these protective laws, and to what extent they really benefit workers? Second, perhaps related question would be, are these new, well, maybe not new, are these type of protections accessible in practice to workers? Can they really exercise them and bring them better protections, especially in countries with weak labor inspectorate or with less experienced judicial capacity on platform work? A couple of questions on the methodology, and Simon, you, Jackie, also know that I am not a labor lawyer, but I work with labor law, and my specialty is in technology and digital rights. So I am very, very curious about the applicability of the coding and the scoring system or the scoring method, specifically for these matters, for algorithmic management, or for the rights that the Platform Work Directive has attributed now, as Simon just mentioned. Can we perhaps think about the similar scoring method for the data rights, or would that require a different scoring method? Something to think about. Of course, you mentioned that this index will extend to algorithm management, which is something that I'm very much looking forward and maybe be somehow following along. But I would like to know whether you have thought about whether the methodology can be applied in the same way to the other part of the platform work, which is the technology or the inside of the company. And then the third pillar of my comments is about the noteworthy elements to highlight from your research. It's very interesting that some countries did show a regression in protection due to many several causes, like the US or the UK and Brazil that you have clearly explained. But also, I'm very happy to see that other countries in different jurisdictions have adopted a presumption of employment already in 2024-5, which is Mexico and Canada, very different countries, but still in North America, being part of the same bloc, Canada, US, and Mexico. But already two of them adopted the presumption of employment, making a really interesting policy shift now, squeezing in a way perhaps what is happening in the US at the moment. On another noteworthy element would be that the transformation is possible. So you really highlighted that some countries have moved on from maybe 0 to 1 or from 0 to 7.75. Also very different countries, Belgium included, Canada, Croatia, Portugal, and Spain. So that's also a good point a good finding in your research. Yes, we know that's the success of the platform firms in resisting the changes, whether by employing lobbying practices or by litigation. And also it's interesting to see China, which is, to be honest, the first time I really look into China's tradition in platform work, with the guidelines in introducing a third category of protection. Would be nice to see, to hear you more perhaps in the detailed comments. How do you see China's position in introducing a kind of a third category of protections via a guideline, if I understand correctly? Just to close, Jackie, allow me to provide some looking forward suggestions or comments for the team and for the research in general. Well, I think that this is absolutely great to have a global view. Even with 95 countries, it's still very global and broad, but would be interesting to have also specific regional breakdowns, especially in Latin America and then in Southeast Asia, and then maybe compare them with Europe, because I think that it's worth learning from what is happening. We also have some similar work done by Fair Work in this area, so it could be a cross-fertilization from both works. It could be also good as a team signal that strategic litigation initiated by workers or unions is somehow there. How would the bottom-up legal mobilization feed into the index and the contact that you have built? How would this influence the legal change? It's also a question to reflect upon. And I mentioned before, I'm really working on technology law or digital law and data rights in particular. And for future iterations, I could be very interesting to integrate how algorithmic management could be connected with the labor law, and how digital rights have been improved or implemented in the different countries now that we have not only GDPR but also the AI Act and the Platform Work Directive. And well, basically these are my 4 main pillars. I again want to congratulate and happy to comment on further. Thank you. Back to you, Jackie.
Thank you very much, Aída. It's not very often, I think, in a labour law or employment seminar, you actually say reasons to be cheerful, part 1, 2, and 3. So surprisingly, what was very interesting, I think, when we started Digit One was, it was all, the big debate was about gig workers platform. That has changed somewhat because of what Simon's outlined in the way that these cases have been contested, and that contested terrain of the whole space of employment relations in that sphere and its relevance to wider sectors. And it's not obviously finished, but it has also moved us on to these issues around algorithmic management. How's that regulated? It's absolutely fascinating to follow how there are capacities for transformation and change. I'm going to let Simon have, if he'd like to respond to both of our discussants, and also to open up, because we've got a very wide international audience, which is absolutely fantastic. I can see from Australia, North America, and Asia. So we'd also, and other parts of Europe. So please, if you have some questions, if you want to either raise your hand or put them in the chat so I can try and keep an eye on them. But Simon, do you want to respond to what Aída and Tim have said?
Yes, of course. Thank you, Jackie, and thank you very much, Tim and Aída, for your feedback and comments. Firstly, with respect to the UK situation that Tim was addressing, we know that the issue of employment status is on the government's agenda, is part of Make Work Pay, which is our plan for labour market reform. We haven't yet seen, have we, a law tabled that would address the employment status issue, but Make Work Pay says that 2 things would happen. First of all, there would be a single status for workers, and secondly, there would be some attempt to draft an anti-avoidance clause, which lawyers will say can perfectly well be drafted. And in fact, there are definitions which would greatly expand the current scope of labour law already available in our legislation. For example, the definition of employee status for whistleblowing purposes could very well be used, and there are others. So my assessment of the UK situation would be that labour law as a whole, and digital law to some degree, provide the protections needed in many cases. The Employment Rights Bill would make major changes with respect to sector level bargaining. That's certainly the case initially for one or two sectors, but it could be rolled out. An interesting feature of the comparative evidence is that there are trends towards sectoral bargaining, specifically in a number of countries. I think labour lawyers and policymakers recognise that company by company, plant or workplace level bargaining isn't always going to be effective, and especially not for the platform sector. It's very difficult to organise. What's happening in Massachusetts is very interesting because that's a sectoral collective bargaining model for independent contractors, which is really very radical, I think, and very interesting. And maybe that also can be taken on board by the government as it rolls out making work pay. With respect to Aída's comments about the global picture, yes, there are several countries, I didn't mention this in the presentation for lack of time, but it's contained in the source book for the index, where legislative proposals were made over the course of the last few years, but haven't come to fruition. So that's probably because of lobbying pressure. Argentina, for example, is one such case. There are others. So I think what we see there is legislatures considering plans for reform, but a lot of encountering a lot of resistance, and sometimes the resistance might be about technical issues, but much more often it's about policy issues, with some governments taking what they would no doubt see as a strongly libertarian or pro-flexibility position. But of course, the evidence very much suggests, and I guess Tim made this point, that labour protections are broadly consistent with increased productivity as well as worker well-being, and indeed with economic growth. Recent work by, for example, the Nobel laureate Angus Deaton on the US position, not just with respect to labour law, but the enormous income inequality which has occurred in the United States over the past 30 years and to some degree has been replicated in the UK, is anti-growth because it's reducing consumption and funneling income up to higher income groups in society is depressing growth actually, as well as tearing apart the social fabric. So I think there's a strong case for universal labour standards, and maybe if we're moving away from employment status, if we have to in some situations. On the other hand, keeping the employment contract is important because in many cases, the employment relationship is a basis upon which workers who are not in a platform sector access rights. And I don't think those rights ought to be diluted simply because of the platform sector problems that we've been discussing. As Tim said, we don't necessarily want to let the platform sector tail, if I can put it this way, wag the dog for labour law. So lots of interesting issues. Again, Aída's point about China, absolutely. My understanding about China is that although the guidelines create a third category, the academic literature suggests that very few courts are finding employee status or using the guidelines even in a Chinese context. But I think more research has to be done on the China case. Thank you very much, both of you, for your comments. Feedback.
Yeah, thank you very much for all of you. We've already got some other questions. So Greg Bamber from Monash in Melbourne, would you like to ask your question next?
Well, thanks, Jackie, and good evening, Simon and everyone from Melbourne. Can you hear me okay?
Yes, fantastic.
Thank you. I think this is really very interesting and important work, Simon, that you and your colleagues are doing, as the astute discussants have observed. And as several of you have also observed, around the world, there's often a huge gap between what the law says on paper and the way in which workers are treated in practice. So my question is to invite a few further reflections from any of you on what we should do about this, bearing in mind the variety of research on different ways of the platform workers are treated around the world, and different forms of enforcement in various jurisdictions on such matters. Is there any prospect of extending this valuable index approach to what happens in practice, which is much messier than the law is, of course, and more, even more difficult to codify, I guess?
Could I suggest taking, because there's two other questions raised from Callian and Tivisha. So could we take those as well? And then after those three, we'll come back for the panel to respond. And in response to Greg's point, I'm just going to post a little link in the chat of summarizing some of the other research we've done around employment contracts in the past 5 years that complement with qualitative research the kind of very important work Simon's done, and some of the work we've also done in Leeds on the Platform Protest Index. But Callian, would you like to introduce yourself as well? Thanks very much.
Hi everyone. Really interesting stuff. I work with a group called the Workers Observatory that supports platform workers in Scotland mostly to inquire into their own conditions and see what they want to be doing about it using data science and other methods. So it's great to hear about this kind of legal framework as it's developing, and we've been discussing methods with others elsewhere around the world. I guess I've got two connected questions. One is I didn't hear that much around the migrant status of so many workers in this sector. Does mean that sometimes the more formal character of employment law excludes people who otherwise wouldn't have a way of earning any money if you end up formalizing things to a certain extent that you're maybe describing. So by ranking up and giving a higher number, the impression is that that's better, but it might actually be a great deal worse for some of the most vulnerable people who are working in this sector. So I just wondered whether you had any reflections on how the kind of exclusivity of employment rights can be avoided from being bedded in, especially in a world where migration and migration crises and the rising tensions and everything around that are obviously going to make us concerned about anything that would privilege one group of workers over another. I suppose the second question is related, which is that when we're working with workers, they're tending to identify those kinds of rights as being the more critical ones. It's around avoiding racism, exclusion, deactivation, the kinds of things that would enable them or exclude them from the workplace, which aren't necessarily quite the same as the kinds of rights that you're spelling out in this study. But I think that there's a crossover definitely from our point of view between the two. So that links really to the point that some of the labour laws that are being pushed by organisations that haven't necessarily integrated gig workers collectively into their structures. So it's just about that kind of democratic gap between the demands that are being made by workers and what you are ranking as being the most important objectives from a legal point of view. But thanks very much. I mean, it's really valuable and interesting stuff.
Thanks very much, Cillian. Visha, do you want to ask your question? And Silveriani, only wait for those three to be responded to before I take you up. Have I pronounced it Visha right, or have I?
Sure, it's Twisha. Thank you.
Visha, and do you want to say where you're from?
Sure, thanks so much. Thank you, Simon, for that really interesting presentation. It was very fascinating. I'm Simon's former student, and I worked on the CBR LRI index for my PhD thesis, and I now work at the ILO. So I had a question which actually might be related to Callian's second question, because as I was listening to you, Simon, I was wondering how this index might work in combination with the CBR LRI that you described as the parent index. And I was also listening to you describe the scoring methodology. And if I understood correctly, you mentioned the score of 1 is the presumption of employment as it is in the Spanish Riders Law. So I'm just wondering, does that score of 1 represent the highest possible legal protection we can imagine for platform workers? I mean, I assume so, because I don't see anything more than a presumption being in place. But then in terms of how it connects with the CBR LRI, does that mean for the countries that do score 1, like Belgium or Canada or Mexico, does that mean that we can take the CBR LRI index that provides information on other kinds of rights like annual leave entitlements or dismissal protection, and then assume that that is the score for platform workers in the countries that score 1? So I was just wondering if I understood that correctly. Thanks so much.
Okay, I'll let the panel respond to those 3, if that's all right with you, Sylvia. Yeah.
Yes, of course. Thank you very much. So in a sense, there are three questions about methodology and the scope of the index, I think. Greg's asking about coding for enforcement. And Kellyanne asks about migrant work. And Twisha has just raised the point about the interaction between the 2 different indices. So essentially, with respect to enforcement, Greg's absolutely right that we need to get a measure of enforcement if we are to understand how these rules actually work in the economy. Enforcement is difficult to capture, of course, by just looking at the legal texts. However, there are, of course, some laws about remedies and about enforcement, which are to some degree coded in the main index. So we do say something about dismissal remedies, for example. It's perfectly possible to design an index which looks at what the law says about particular remedies and enforcement, but perhaps that's less interesting than evidence about how labour laws operate on the ground in practice in workplaces. To get access to that evidence, I think we need perhaps to think about case studies, surveys, a range of different means of accessing that information. And we can't just be content with an index. I'm not sure that indices are always the right answer to these questions. But I think what we can say is that the index captures trends in law. And we know from previous research that very often when a law is passed in a given area, it stimulates collective bargaining, and it may also lead to enforcement through inspectorates, depending on the circumstances, right? So not having a law is a problem, right? Not having enforcement is a problem. But if the issue of platform work is to be effectively addressed, I think there has to be progress made in both fronts. It's not enough to say enforcement if the substantive rights just aren't there. Building an enforcement index is something we are actively considering. That may be a next phase. Also, with respect to migration, we're actively building a migrant workers index at the moment in a related study. And the aim there is to see how far the special regimes for migrant work in particular countries and particular sectors, because it's often sectoral, how far there's a gap between the position of a migrant worker and a non-migrant worker in a given country. And this can be done legally as well as practically, because we have access to a lot of the very complex information about how migration law works. There are lots of different regimes. So we're actively trying to benchmark the degree to which migrant labour is legally treated differently, for example, under seasonal work schemes and other schemes, which don't always affect platform work, but are certainly important for migration. And I think we need to do more case study work. That's also being done in our research group here at Cambridge, examining the current migration flows from Central Asia, for example, into the UK in sectors like agriculture and also education as a major sector affected by migration and health. So I don't think an index can necessarily answer all these questions, and I think that maybe but for sure there's a continuing need for case study work and other data to be collected through surveys and otherwise. A global survey on all these questions may not be plausible, but country by country, region by region surveys ought to be funded, in my view, by the relevant research agencies. Obtaining research funding is always difficult, of course. It's not getting any easier in the current circumstances for the ILO or for other agencies, but I think there's a clear need here. With respect to Twisha's question, absolutely. So in a sense, the 2 indices fit together because expanding the employment status category ought to give access to labour law rights to platform workers. And of course, there's already an indicator in the main index which relates to employment status. It was coded a little bit differently. The aim here is to capture the highest score just for platform work. The main index covers, of course, employment status for all workers. So the two scores don't align. They're fulfilling different purposes. However, the indices are meant to be read together. So we're also carrying out work at the moment on 0 hours contract work, on leave rights, and also on trade union rights, deepening our current index for the UK Department of Business and Trade as part of the work being done, analysing the Employment Rights Bill. And that work will be published, I understand, later in the year. So the index methodology is sufficiently flexible to be applied to any context, basically. Increasingly, we're finding that we can take the basic model and extend it to other areas of labour law. And also then, I think, of course, to digital law too, to go back to Aída's question, there's no reason at all why the same methodology cannot be applied to digital rights. I think at the moment, it's a little bit early to see exactly how far those digital rights are taking shape at member state level under the Platform Work Directive. It's a bit early, but I should have thought within a year or so we should be able to start coding for that process too. Yeah. Thank you.
And Aída, if you would like to add anything, you're very welcome to, and then I'll take Sylvia.
Can I just say just a couple of words about enforcement? I think that picking up on those issues around enforcement is quite key. I think it's one of the great weaknesses, certainly from a UK perspective, that you know, if you a strong union presence means you've got people in the workplace who can tell workers of their rights. You've got people who can remind employers of the duties they should be undertaking, and that's one of the weaknesses we have in the UK, particularly in the private sector. There is little trade union presence. We also have an underfunded state enforcement system with very few labour market inspectors, and we have a tribunal system that's you know, a legal system that has such big backlogs that it takes workers months, if not years, to obtain justice. So it's a major issue if we're going to obtain better outcomes for platform workers and others. Colleen had a couple of questions about sort of migrant workers and about sort of the worker perspective in this. And I think again that's where collective bargaining and the role of a sort of collective voice is important, that one that doesn't necessarily rely on an individual worker taking a case through the legal system, that they've got, that there's people who can speak on their behalf, or there's norms put in place. And I think one of the things we're keen to press on the current government when it comes to state enforcement is the desirability of a firewall between immigration services and workers' employment rights enforcement. That if a worker worries about what their immigration status will be, or if they've got uncertain immigration status, reporting that, they're less likely to want to report that to the any problem where employment law problems to the authorities in case it affects them. And likewise, we're keen to see reform around some of the issues around short-term visas. You can't enforce your rights. You're unlikely to be able to join a union. You're unlikely to take cases through the tribunal system if you're only here for a matter of months. And then just on that really final point that Kelly made about sort of worker voice, I think that's it's a sort of good challenge about, is there basically, I think it was effectively, is there a disconnect between what workers actually want and what, you know, the index captures, and maybe what groups such as the TUC and our affiliates might be advocating for. And I think it's a valid one. I think that's why it's really important that the barriers to trade unions organising in emerging sectors are lifted, so that we can engage directly with workers on the front line. We also have to think as well about how employment status is formulated. So we know that a lot of people in the platform economy, you know, they welcome some of the flexibilities that platform work gives them, but we need to work out how we can capture some of those advantages of the flexibility within the protections that employment status gives them. Thanks.
Great, thank you. And Aída, you don't have to say anything, but if you want to,
just
you're
very quickly, it's interesting to hear that this methodology can be used for algorithmic management, because platform work is so special. It combines labor law, but also data protection and digital law, that it can be used to cover the second part of platform work. And indeed, in a year, we still don't have enough meat to go into a thorough selection of decisions, but in a year time could be definitely possible. I just wanted to add, Simon, if I may, that it could be also very useful to see decisions from data protection authorities, which are also very relevant, covering how not only platforms have been misusing data rights, but also the fines that the platforms have gotten because of that misuse also have something to say. So it just added these 2 points on the fines, the power of the platforms in producing them, and the GDPR data rights. Thank you so much.
Thank you, all three of you. It's great. Can I hand over now just to Sylvia Rianone from the ETUI in Brussels? Would you like to briefly introduce yourself? And if anybody has any more questions, please, either put them in the chat and I'll call you, or put your hand up however. Yeah, Sylvia.
Very much. So yeah, I'm Silvia Renon. I'm senior researcher at the European Trade Union Institute in Brussels, indeed. So thank you very much for this extremely interesting presentation. I also went through the working paper, the report and the index itself. I think it's extremely valuable and accessible. So thank you for this. I have a question concerning, let's say, the methodology, but more the sources. I was wondering, how did you collect the material from these 90 plus countries? Do you have expert that you were sending the questionnaire, for instance, or you have your own repository of legislation that you could translate? So I was wondering more the access information aspect. And then I was also wondering if this is something you may want in the future to update, because I see that, well, the highest score has been assigned I fully agree with it. It's the best practice probably we have with the Ley Rider in Spain or the Platform Work Directive. However, none of those instruments are flawless. So the Ley Rider is sectoral. The Platform Work Directive introduce a very general presumption based on control. So we may in the future, I hope, have 1.25 or 1.5. I mean, can we go higher? This is something I was wondering. Thank you.
No, thank you very much, Sylvia. Yes. So in terms of the methodology, we're basically following the same method we used for the main index. We don't have a big team of experts. We do the coding ourselves. It's possible to use experts, but because we have so many countries, it's difficult to achieve that. In place of experts, we have a quite precise coding protocol, and we think that it should be possible to arrive at not necessarily a uniquely correct score for each unit, but for there to be as little doubt as possible over the scoring, given the template and given the explanation that we provide. And then we publish the source book. And at that point, national experts can read it and get back to us if they don't think it's correct, and we can have a discussion with them. The alternative of using questionnaires and experts, that's widely used in index construction by the OECD and the World Bank. The codings are not completely subjective. As I said, they're meant to be as objective as we can make them. And when we used experts in the past, we often found somebody would say, well, I don't agree with your score on a particular country for the main index, because my impression is the law doesn't work so well. But we're actually just coding for the protocol, not the way the law works in practice. And I think that the alternative route of using experts, maybe 1 or 2 per country, to build up an index, which is how the main rule of law indices have been created and indices used by the World Bank and others. I'm not sure that always works, because you're relying on maybe just 2 or 3 people in a country. It's the way the World Bank has been creating its new business ready index, but honestly, I'm not really sure. The advantage we're doing it the way we do is that there is a coding template. It's up for discussion. There is a source book, it's publicly available. So we say there's error correction built into the process. We'll update the index in the light of the feedback that we get now. and we will produce further versions. We won't just produce this one. The main index has gone through several iterations. Again, we get feedback from the labour law community about the index. Very few errors have been reported to us for the main index, but where we do see one, we change the score. So I think this is probably an imperfect method, but maybe it offers things which are not available through other modes. Also, there's a discussion about machine learning replacing all this, and maybe ChatGPT could have done the whole thing. But I'm not sure about that. That's for a future day. At the moment, there are machine learning approaches to doing this sort of coding, but there are problems with that too. In particular, a lack of transparency in the way that machine learning algorithms work, including public chatbots like ChatGPT. We don't have full information about how it works. Yeah, you could use it. Now this data set exists. You could use ChatGPT to try to even replicate it. Okay, this may be for another day. My feeling is right now this work can be done by human coders. We don't need to hand it all over to an automated process just yet. But I'm fully aware that there's a debate to be had about which is the most reliable method going forward. And other work we're doing is looking at natural language processing and machine learning as possible ways to manage large amounts of data relating to labour laws. So yes, we absolutely will produce a further version of the index in due course. And if we see other types of laws emerging which are more protective, then we would revise a coding template. That's completely consistent with our methodology. It's a relative scoring, not an absolute scoring. So if the law changes over time, we should change the template. We haven't changed the template for the parent index very much. We adjusted one or two definitions in relation to working time to take into account some of the complexities of reference periods, for example. I think this is perfectly plausible. We just need to be as clear as we can be about the way we use the coding template, and be open to other ways of doing this. Absolutely, whether a somewhat more automated approach offers advantages is something I'm willing to consider for the future.